Oh, yes, you have. Thank you.
So next we have Tabitha, then Stacy. Please keep your questions short and precise in the interest of time. Thank you.
Okay, thank you for the presentation. My first question is, when you're doing a search, you have to have a title deed for that land. So in circumstances where you've been sold a land, that land doesn't have a title, especially for these municipality lands, mostly they do not have either a certificate of lease or maybe a title deed. But then how do you ascertain that this is the legal owner of that land where there's no a land title or a certificate of lease? Then in terms of where you've said about the brokers and such, in terms of a client has been, okay, a client has developed the land, yes, and then the client later realizes that this land is not the land that I was being sold. Even the processing of the title and such, it wasn't that land. So the land, the client develops the land, and now in this case, that land has a title deed, so it amounts to trespass. So my question is, which remedy does this client have? Because one, let me say it was the mistake of the investment company or something, but no, the client is a trespasser. So what remedy does the client have? Yes, those two questions. Thank you.
Okay. Okay, the first question regarding the search, you're saying this person doesn't have a certificate of lease or a title deed. That's already a red flag. Why are you buying property that doesn't have a title or a lease? So as an advocate, you should find out why this property doesn't have a title or a lease, because you can't make your client buy property that doesn't have a title. That's already a very big red flag. Unless maybe it has a letter of allotment, there's a letter of allotment or a share certificate. Those are also documents that show ownership. It's just that this person has not yet proceeded to get a certificate of lease. But if that land doesn't have a title or nothing, no share certificate, nothing, that's already a big red flag for your client. So for me, in such a situation, at least find out why that property doesn't have all those, because it's already a big red flag. You can't be, because remember, I think under the Land Registration Act, like the title shows ownership of that property. That is the thing that, like, if let's say this is my land, what will show that I own this land is a title deed. So that's already a red flag. So I think in such a scenario, you might, like, unless you find out the reasons, and only the reason should be at least maybe there's a letter of allotment or there's a share certificate, that's already a big red flag. And you should advise your client, or if you are the purchaser, to not proceed. And then on the issue of, after you've already done you did your search, you've done your due diligence, and you've gone ahead to develop a property, and then you come and realize this is an issue. I think now that's what I was telling you, this is where the sale agreement comes in. Like that's vendor's warranties. It's normally, I think if you have seen that sale agreement, the vendor's warranties are normally like 20, a list of like 20, almost a whole page, where you put everything. Like they have to ensure that there's no arbitration, there's no matter in court. The vendor warrants that he's the owner of this property. The vendor warrants that, that's why you put everything there, so that in case something comes up. So in such a scenario, if now you've already developed the property and something comes up, now that's where you go back to that sale agreement. Because that's what I was telling you, the sale agreement is everything in the land buying process. So that's why you should make sure, that's why I normally say those 2-page sale agreement. So that's why you should make sure your client is well protected in all such scenarios. And then when you're saying maybe it's the problem of the investment, no, I think everything narrows down to when you are buying that property. Because if you do, and then another thing I was also telling you, if you have done a search and then maybe the property, let's say for instance, that property belonged to another person. If you did it the right procedure, where you went to lands, you did the search, like you filled in the form, you got because I think if you have done a search in the land registry, it's normally 1 page, like back-to-back page document. The first page you fill in, then they fill in the behind page. So if you have that document, you can actually sue the land registrar. So of course, here you'll be suing for damages, If, for instance, that property belongs to someone else and that person wants back the property, you'll be suing for damages. So they'll get the market value of that property as at that time when that was found out. And if you had the sale agreement and you did your due diligence using the right procedure, at least you'll have remedies. I think that's the best way I can answer that. I hope I've answered your question well.
Yes, it's okay. Thank you.
Now we'll have Stacy, Jeff, and MK, and then Kathini. Just limit your questions, just limit because of time. Thank you.
Okay, hello, can you hear me?
Yes.
Yes, I can hear you, Stacy.
My question is regards to professional undertaking.
Okay.
Yeah, so what goes on when a lawyer, an advocate takes a professional undertaking for their client, now the purchaser, and then they are unable to, the transaction is not able to go through, or the passing of the land is not able to be because of financial culpabilities, and in terms of the money is being held by the bank. So what happens to that professional undertaking?
Yeah, as I think I stated, like when doing the professional undertaking, depending on what you're undertaking, you normally put also, of course, you also assume the scenario where whatever you're undertaking doesn't take place. So there's normally a clause where you put what happens in such a scenario. So if maybe, like for instance, you have said the purchasers, maybe the purchaser's advocate had promised that there's money. Of course, maybe they're expecting money somewhere in such a scenario, and then the money, maybe they didn't get the money. So you have to, they should be, so maybe what happens is maybe you pay 10%, like the vendor gets 10% of the value, maybe the market, the value of the purchase price. So it's normal, there's normally a clause which states what happens in case then what has been undertaken doesn't take place.
Okay, next, Jeff, and then we have Kathini, MK, and then Kathini, then we close. So Jeff.
Hey, good evening.
Good evening.
You talked about postal search, and alongside with it, you talked about green card. Would you be so kind to enlighten me about green card?
Okay, so at most all the title deeds, you know, that's why even they normally say, yeah, your title deed might be stating your name, but what, even in court, in case you have an issue in court, like about ownership or the original owner of the title, that's why you normally see in such cases the third party, or maybe if there are two parties, or people normally put the land registrar as a third party in that case, because they want the green card to be brought. The green card is normally, it's in the land register. I don't know how best, it's normally, it's both, mostly just by that there it's just said it's a green card. It's actually a green card that is kept at the land registry. That is now it's more of the original, like stating who is the original owner. So it has the proprietors of that property from who was the original owner. So because you may find someone has sold property 10 times. So you'll find the green card now has who, like, so that's why there are people who, when they go and do a search, they want to do a historical, like want to know who are even the previous owners. So that's what the green card even contains, because then green card will have all the owners, all the original owners of that property. From, let's say, even like since they, like for very, like, I don't know even how to explain it, like the green card is one that has all the proprietors of that land. So that's why I was saying, when you have to do a postal search to confirm that you have already been placed as now, maybe if you're buying for the fourth time, you're the fourth proprietor of that property, because that's where it states the sequence of how people have owned that particular property. But not all titles have, there's the IR titles, they don't have green cards. That's why even if you have an IR title, it's normally, all of them, even though your property is in Busia, your property is in Mombasa, all of them are normally done at the land registry. Those are the properties that are, I don't know, they're under which, I'm not so sure if it's a relay or, that's why for them, they don't have the green cards. So that's all of them, they're normally done at it's only the Nairobi registry that can do the search of such properties. So basically a green card is, it shows ownership, proprietorship, the way it has transferred. I hope I've put it well, because that's what I was saying, like you may find someone even has forged a title. So, and for you, we have had a situation where two people are arguing over one property. So the only like the only thing that will actually show who the original owner of that property is the green card. So that's where the land registrar will be brought in as a third party into that case to bring it to provide the copy of a green card or the copy of the green card. I hope you have understood that.
Thank you.
Yes, I have.
MK and then MK and then Kathini.
Okay, I have two questions. Number one, when conducting a search, do we conduct the three types of searches all at once, or do we?
Sorry?
When conducting a search at the registrar or at the registrar's office, do we conduct all three searches? And
By three searches, you mean the historical search, private search,
and the official search? Yes.
Okay.
Okay. The second question I think Stacy was trying to get at it is when I get when two advocates, the vendors and the purchaser advocates, get into an agreement, a sale agreement, and then it does not come into fruition because the purchaser's advocate had kept the money in a bank and the bank goes into receivership. What can the vendor do? Do you just rescind the agreement, or there's something that can be done?
Okay. So to answer your first question, no, while doing a search, it depends. You know, the searches, I think they depend on the type of the property is registered under, because like, for instance, the historical searches, I think you only do the, I'm not so sure. I'll confirm that. So many only under the GLA titles. GLA titles are the only ones that you can do, GLA titles are the only ones you can do a historical search. And then, so it will depend on the title deed that you have. So if you have the freehold, the normal freehold title deed, you just do the normal private search, the normal search, not the private search, sorry, the normal search. And then there is, I think, just a minute, let me confirm the issue of the searching. And then on the issue of the way you're saying, if in case, as I check, I can be answering the other question because of time. So I was saying on the issue of, if in case, then you're saying that in case the company, if you're given an undertaking and then the bank maybe goes on receivership. But there was, as I said, you know, it's just like an undertaking is more like a sale agreement where you're, in case you've put all the scenarios in place, in case the other party doesn't, let's say, for instance, now in this case, if it's the vendor, if it's inside, you have to put any undertaking you're giving, you have to give the other option, if in case that you don't get to do the undertaking, like you don't get to, if, for instance, the undertaking was to give money or something, if you don't get to do what you have undertaken to do, there's normally already some, like you have put the other alternative. And normally, and also undertaking, and also another thing about undertaking, they normally, like for instance, if it's like for banks are normally so strict to the undertaking, so you find they even give a limit, like it will stay until this amount of days. So I think if it was there was something coming up like receivership, the span of time won't even be allowing for that to happen. So basically what the normal undertaking, you have to put what happens in case what you have undertaken to do doesn't happen. That's how everyone, whether who's giving an undertaking or who's getting the undertaking, protect themselves. And then on the issue of the searches, no, you can't do the entire 3 searches, because as I was telling you, it normally depends on the title. If you have the normal title, the RL, you will do the normal search. And then if you have now if you have like GLA, yeah, I've not gotten it. If you have a GLA title is when you can do a postal search. GLA titles are for postal searches, and then for RTA, sorry, let me. And then, and also, as you know, there's something like personal search also can't apply to, it applies mostly to also like titles under, because you know, there are ones where maybe you want to get I think this is the common one that you normally do the personal search. So, but like to answer your question, you can't do all the 3 searches. It will depend with the title you have. Because if you have GLA, when you have GLA, you're going to do the postal search. If you have the RTA and RLA, you're going to do the